Do you have probate court in the state of Missouri coming up? Here's what to expect and how to prepare. Facing probate court can be intimidating, but it doesn't have to be. Today, we're walking you through exactly what to expect in Missouri probate court and how to prepare so that you can approach it with confidence. First, I want to introduce you to the basic concept of the probate court system in Missouri. So importantly, what it is. Probate is the process of when somebody dies with property left in their name, that property has nowhere to go. If it doesn't have a beneficiary, it's not in a trust, it has nowhere to go except to the heirs. And the system that we create to transfer that property is called probate. It's an in-court process where we have to file some paperwork with the court, and sometimes it's supervised, sometimes it's not, sometimes it's long, sometimes it's short, sometimes it's expensive, sometimes it's not. It really depends. But probate is that process for transferring that property. And sometimes we have to have hearings in front of the court. And essentially all that means is that we show up, we put you on the stand, you tell some stuff to the judge, we ask some questions to you, and you explain that to the judge because we're trying to create a factual record for the court so that the court can actually enter a judgment on evidence rather than merely allegations. And one of the ways we get that evidence is through things like documents like death certificates, wills, your testimony in some cases. And that's how we get the information that we need to create many of the probate court judgments. So here's some of the key players in the probate system. Number one is the judge. So in probate, they're like the goalie. They're different from the judge in a civil case in many ways. In a civil case, the judge is presiding over the pleadings, the arguments of the parties, and they're making decisions about whose argument is correct and whose argument is not. In probate, they do that sometimes, but another big role of the court is to make sure that the probate system's rules are being followed accurately. Meaning, are you filing the right stuff? Does the stuff that you file contain the right information that is needed? Did you provide all of the right documents to process the case correctly? So the court also acts as a goalie and a process enforcer in the probate system. So we need to satisfy the judge. The judge is the person we need to make happy through the probate court system in many cases, especially in uncontested cases. Okay? The other group of people involved in probate are going to be the attorneys. In most cases, an attorney is required to help in the probate process with a personal representative. There are a few exceptions in Missouri for creditors and spouses and things like that, but for the most part, in a typical probate administration, you have to have an attorney. And if there are heirs involved who may have a dispute with the estate or the representative who's applying, there may be more than one attorney. So their role is to advocate for the interests of their client. In Missouri, the personal representative may retain an attorney, and that attorney represents the interests of the representative. Now, they also have kind of a bifurcated dual role in that they also, in representing the representative, there is some duty to make sure that the heirs are being informed within compliance of the fiduciary duties of the representative. They have to follow all the requirements of the probate code. But there are usually going to be attorneys, one or more attorneys involved in the probate process. The third group of people involved in probate are the personal representative of the estate. This is only in full administration. If there's a short form administration, like a small estate affidavit, or a determination of heirship, or a refusal letter application, the representative might be called something else. They might be called the affiant, the person who makes an affidavit, or the petitioner, the person who's filing a petition to declare the heirs. Right? So it's not always a personal representative, and it depends on the details of the case. The last group of people involved regularly in probate are the beneficiaries or the heirs of the estate. So they have to be notified of the proceedings. In most cases, they need to be tracked down. The court's going to require us to, in many cases, do background checks and see what we can do to find the addresses, the mailing addresses of all the heirs in the estate. Now, let's move on to the question that we started with today is court hearings. How do we deal with these in Missouri? In Missouri, fortunately, many of the bigger counties like St. Louis City, St. Louis County, Jackson County, they allow virtual appearances through WebEx. So in many cases, you won't even need to go to court physically. Now, even when you do need to go to court physically, if you're in a smaller county or a county that just doesn't do as much virtual appearance, usually you'll be in court only where either evidence needs to be taken or there's a dispute over something, right? Or there's not broad consent. So one of those is over the appointment of a personal representative. If you don't have consent from all the heirs, there may need to be a hearing in order to get the representative appointed. Sometimes that hearing is just a formality. We show up, nobody else shows up, the court says, thanks for showing, bangs the gavel, you win. You're now representative. Sometimes it's as easy as that. If other people show up, there may be testimony taken about why a personal representative is a good choice or a bad choice. And that information is, the judge decides on that information on what to do. Are they going to appoint this person? Are they going to appoint a third party? How are they going to deal with that? And the judge is going to look at things like, are you a trustworthy seeming person? How's your financial situation? Are you in debt to the estate by a whole bunch? Are you an adult? Are you bondable? Are you going to be able to purchase a surety bond and pass underwriting? So they'll look at all these sorts of things. The other type of hearing that we'll commonly see are miscellaneous petitions in a supervised estate. We may need to file a petition to expend funds, like to pay the attorney or the CPA or pay for an appraisal. We may need to file a petition to sell real estate or other personal property belonging to the estate, because in a supervised estate, you can't do whatever you want with the property without first asking the judge. So that is an important part of that process, is getting those miscellaneous petitions on file. Another group of time when we're going to regularly see hearings are going to be in a determination of heirship proceeding. And what that is essentially a court hearing where we're deciding who are the heirs, here's the evidence who the heirs are, and the court enters an order determining, all right, these are the heirs, the property goes to them. Okay, that's another very common area where we will have court hearings. Now, those hearings are typically very short, very simple. We have the client on the stand. They explain who died and who their children were and what the property was. In some cases, those hearings are disputed if there's an issue of, I don't believe that this person was actually a child or descendant, but that is not super common. So how can you prepare for your court hearing? You can start by organizing and preparing any necessary documents. Most of the time, we've already got this stuff filed with the court, but if there are any documents relevant to your particular case or your particular hearing, it might be helpful for you to have reviewed those documents in advance and be ready to talk about whatever it is that's happening at that hearing. Now, you may want to talk with your attorney beforehand. Hopefully your attorney will reach out to you and prepare you for what to expect, what the hearing is about, what questions they're going to ask you. But it's a good idea to touch base at least for a little while, 15, 20 minutes, just to go over what those questions are going to be and what to expect at the hearing. You're going to want to dress appropriately, look nice. Because again, we're trying to impress the judge. We're trying to show why you're a trustworthy person to do these jobs and why your testimony should be believed. So you want to look good and be a good source of evidence for the court. Now, during that hearing, we're just going to be putting you on the stand, asking questions, the representative or an heir, in order to get evidence in the record so that we can get a court order. Maybe real estate needs to be sold. We need to explain why it needs to be sold. Maybe there's creditor claims out there that need to be satisfied or bills that need to be paid and we don't have any cash. Things like that need to be looked through. So being well prepared for a probate court hearing can make the process much smoother, less stressful. So if you need any help, don't hesitate to reach out to us. We're here to help guide you every step of the way. Be sure to like and subscribe down below and hit that bell icon for more useful advice. If you ever want to connect, reach out to our links in the description. Thanks.